First, Your Honors, I wanted to thank you for granting the motion to expedite the appeal. That was an obvious cause of concern for us, and I appreciate the opportunity to be here. And I consider it an honor and a privilege to speak before you today. I wanted to draw a little bit of a comparison. We're talking about the Kahu Forest Reserve, which is comprised of in excess of 41,000 acres, as compared to, 61,000 acres, as compared to Honolulu, that has 43,000 acres. I thought that I want to raise basically four separate issues that weren't addressed in the briefs, but clearly refer to the briefs. But I think the briefs sufficiently brief the law and the facts, and so I'm going to be very brief myself in terms of the points I want to raise. And the first is the chronology, because the chronology tells you something about why we're here. The June 2nd, 2012 meeting that occurred in Kahu, that's referenced in the environmental assessment section at pages 15, 63, and 72, states that the DLNR conducted a public meeting regarding their proposal for the eradication of the ungulates, but more specifically the pigs, and also the fencing of the substantial acreage that would be costing in excess of $150,000 per mile. The presentation was made to the 100 Kahu residents that appeared, and according to the EA sites that I just gave you, almost 100% unanimously objected to the fencing and the eradication of the ungulates, but more specifically the pigs. So that was on June 2nd, 2012. On October 23rd, 2012, the DLNR published its notice of FONSI, the finding of no significant impact. And then on November 20th, 2012, PDF filed its complaint. The DLNR moved for summary judgment. They filed their motion on December 5th, 2013, March 17th, 2014. Final judgment was again entered against DLNR. And on April 5th, 2014, PDF filed its notice of appeal. On December 6th, 2014, briefing was completed for this appeal. And that brings us here today. There's basically 5 different admissions that we believe should be pointed out to the court that, as I mentioned, are referenced in our briefs, but I wanted to highlight them. No objection was made by the DLNR to the declarations filed in opposition to the motion for summary judgment, and all of the declarations, were admitted into evidence, and that's an issue that we're obviously raising on appeal. It substantiates the claims that we've raised that justify our request that this case be reversed and sent back for an EIS. The declarations included the declaration of Pele Hanoa, Polly Kapu-Dedman, who's here today, and also Ryan Kahatsu, and then myself. I authenticated some documents. And but the undisputed evidence shows that the cultural impact assessment, the CIA, contained numerous errors by failing to consider that proposal. That would show that they interfered with the subsistence, traditional, and cultural activities of Native Hawaiians as required by Article 12, Section 7.
Counsel, is it your claim that they failed to consider it or that they improperly concluded?
They failed to consider, and the test is may have a substantial impact, and they didn't consider. So it's that. May I get a drink of water, Your Honor? Okay, the undisputed evidence also shows that the significant impacts, which meets the requirements under the significance criteria in H.R. 11-200-12, subsections 1, 2, 4, and 9, were all a matter of record by virtue of the admission of those declarations that I mentioned. And the
Mr. Dombrowski, if I could, I think the first thing I'd like to, if I could just kind of cut in a little bit, the first thing you argue in your briefs, and I kind of want to kind of get it out of the way, which is what's the test that we apply here, right? And so when the parties did their briefing on appeal, there was maybe some question as to what the appropriate standard would be. There's at least some cases that kind of spoke to the question, but since then, the Kila Kila or Haleaka Law case was decided by the Supreme Court. Are you familiar with that opinion? Right, okay. So, I mean, you would agree with me, I imagine, that that case is very similar to this case. It's a question of whether an EIS is required after an EA was done?
yes.
Okay. So we're looking at, bottom line, likely significant impact to the environment.
Correct.
Okay. So in terms of that, what I would like to kind of identify first, you mentioned the traditional custom and practice issue. What other impacts are your clients alleging?
Well, they just addressing the standard of review, we submit that regardless of what standard of review we want to apply, which we initially we're challenging the arbitrary and capricious standard that was applied by the trial judge. But under that standard, or the standard that we encouraged under the case, the Kipo'o case, that you are entitled to just make a showing that there may be a significant impact. Under either one of those standards, we have evidence in the record that clearly show there not only may be an impact, but there in fact is an impact.
Plus may have a significant impact. That's the actual language. And in Kipo'o, I think there's a discussion about may actually meaning likely. Is that correct? Okay. So in sum, whether there's likely to be a significant impact on the environment. So my question to you is, what are the particular significant impacts that you are alleging? Now, so I asked you this because in the briefs, it seems like what you have discussed are the ungulates, particularly the pigs, the removal of the pigs from this 12,000 acre area, and the birds, the reintroduction of the Hawaiian crow. Are there other impacts that your clients are alleging or claiming would occur to have a significant impact?
Yeah, well, the ones that are most obvious and that we've addressed in the briefs, of course, is the eradication of the pigs,
right,
which is a direct violation of Article 12, Section 7, and the notion that wasn't taken seriously and considered, and we submit that clearly shows that the significant impact of that effect, especially based on the testimony of the folks that appeared at the so-called public hearing.
If I could ask you, I'm trying to understand this a little bit. My understanding, at least, of what they plan to do in this 12,000 acre area is to fence it in at different measures, like I think up to 2,000 square feet acres at a time, not the entire 12,000. But in terms of the pig removal of the pig, there still would be hunting first initially in it to remove the pigs from that area, but also there still would be hunting in the reserve. Is that what your understanding is?
No, Your Honor.
So why is that?
Well, because I don't think that's what their position stated. As I understand it, that's certainly not consistent with facts as I understand them.
The EA actually says that they anticipate allowing hunters to go into the area initially to hunt. So where is it in the record that you would cite that they wouldn't be able to do that, but also that there would be no pig hunting in the remaining 80% of the reserve?
Well, the point that we're making is the fact that eradicating the pigs at all is a direct violation of Article 12, Section 7 as a matter of law, because it takes away a sacred, ceremonial, symbolic symbol of the Native Hawaiian religion. And that in and of itself deserves another consideration in the context of an EIS, because it wasn't considered at all. It was disregarded. It was completely ignored.
I thought in the EA that they addressed traditional customary rights. But so one of the things that I, was looking at is you're claiming kind of as a broad point a violation of the constitutional rights of the Native Hawaiians. But none of the declarations or affidavits of the plaintiffs that were submitted to the circuit court assert basically what I would call the PASH factors for asserting those rights. Would you agree with me or disagree with me on that?
No, I would disagree, because the declaration of Polykapu Dedman spells out the objections in terms of the various reasons and the fact that for instance, at page, this is at RA, the record at 807, he states that the public meeting on June 2nd, 2012 stated that testimony was there was great concern that the entire reserve will be fenced off in the future, and that Ka'u people will not have access to the resources and will not be able to perpetuate and pass on their lifestyle to future generations. He points out in paragraph 11, which is deemed admitted, that the CIA failed to consider the interference with the subsistence, traditional, and cultural activities of Native Hawaiians.
But doesn't in order to assert those rights under PASH, Kalipi, those types of cases, that you have to establish certain factors, certain elements, including that one is Native Hawaiian in the sense of being, having ancestors who were in the islands going back to 1778. Is that,
let me speak to that, Your Honor. I'm glad you raised that point, because this is going to address that point.
Okay.
In the declaration of Mr. Dedman, he attaches the findings of fact and conclusions of law by Judge Amano in the Wa'okele-Opuna case, and they're attached as Exhibit A to Mr. Dedman's declaration. And this shows, and this is one of the points I was going to get to, that when you go to those particular findings of fact and conclusions of law, it lays out basically all these findings of fact and conclusions of law that directly support the issues we've raised here with respect to pig hunting. And for instance, the one that's most pertinent to what I think you're getting at is the one that's this is at the record 166. Oh, excuse me, that's not the one. This is in Judge Amano's conclusions of law and findings of fact are attached, and the record is 815 to 854. If you go to the page 845, finding of conclusions of law number 26, she says unequivocally, and again this wasn't opposed, she says that, this is the conclusions of law, she says, based on evidence presented, the hunting and gathering activities of PDF, the plaintiff in this case, PDF members were customary and traditional, i.e. that these activities were conducted in accordance with Hawaiian norms and values existing prior to November 25th, 1892. And that, we believe, supplies the court with the requisite connection with the claimed right of pig hunting to a firmly rooted tradition or customary Native Hawaiian practice to meet the concerns that I think were raised in the Palama decision.
Real quick, what is the area that's being addressed in Judge Amano's findings of fact
The
conclusion?
Wa'okele-Opuna rainforest and the Puna rainforest, those two, matter of fact, I can direct you to the page. If you go to 822, this is findings of fact number 3. It states that the portions of the land that are the subject of this action are the former Wa'okele-Opuna Natural Area Reserve and the Puna Forest Reserve, situated in the district of Puna, island of Hawaii, which were exchanged in 1987 by the state of Hawaii for lands at Kahu'aele's, which were owned by defendant Campbell Estate. So, but if you go through the points of the conclusions of law, and I can just mention them in terms of the conclusions of law that I believe apply to this case, clearly, I would point out that the conclusions of law number 4 and 5 on the record at 841, conclusions of law 6, 7, 8, 10, 11, 12, 13, 14, and of course 22, 23, 26, 27, 28, and 29, and I could give you the page numbers if you like too.
No, it's okay. You've given us a clear reference to the record.
Yeah, but that's in the record and unopposed, as I said, and we believe that that meets, at least I hope, the issues that you just raised in terms of laying the foundation to establish the Article 12, Section 7 rights for the plaintiffs in this case.
So, and then to take it one step further, then in terms of the Pash, Kalihi rights that are being asserted, the fencing of the area, specifically your contention is by removing, any removal of the ungulates, the pigs from this area, is vis-a-vis necessarily a violation of the rights? Correct. To hunt the pigs?
Correct. Correct. And as a matter of fact, the point that I wanted to make is that eradicating pigs is eradicating a Native Hawaiian religious symbol, eradicating a religious ceremonial object. Your eradication of the pigs in Kau is to eradicate Article 12, Section 7, and it's analogous, as a matter of fact, to desecrating Christian sacraments, because these are Native Hawaiian sacraments you're talking about here. They eat, they hunt, they provide subsistence, and so there's clearly a violation. That's why I describe it as a per se violation. It's clearly shouldn't be permitted, and it clearly meets the requirements of clearly showing a significant effect.
It's not read yet, but...
Yeah, okay.
Counsel, does it make any difference to your argument the size of the area where the eradication is occurring? In other words, if this was 1 acre as opposed to 12,000 acres, does it matter?
Yeah, that's a good point, and I think that it does, because the magnitude obviously is relevant to the extent that it diminishes, it diminishes the location in terms of the hunting of the pigs, but it's still diminishing the acreage, whether it's 1 acre or, in this instance, over 21,000 acres. So I would submit that it's per se, it's a violation. And I think the Palama decision kind of said that in so many words. Of course, it was limited to the facts of the case, and it wasn't precedent in terms of what can be referred to here. But clearly, that's what's happened here, and that's the voice of the opposition by my clients in terms of their efforts to demand a EIS be applied. And so I would respectfully submit that that should be that there should be a reversal and sent back for an EIS.
But I know your red light came on. I do have one quick question. Are you saying then, in response to Judge Rayford's question, that even if it was 1 acre, you would be asserting it is a violation requiring an EIS? Okay, and is it undisputed that we're talking about a 12,000 acre area? That's 20% of the reserve, is that correct?
Correct.
Okay, thank you.
Morning. May it please the Court, I'm Deputy Attorney General Colin Lau for the State of Hawaii. Basically, the states would like to say that basically the plaintiffs have argued 3 basic things, and this is not easy to discern within the briefing, but from what I understand, they're arguing that they claim a traditional and customary right to hunt pigs, which trumps everything. They disagree as to the standard of review and wish to substitute their judgment, and they believe that consideration of exemptions is frivolous. The state, in return, asserts that DLNR rightfully did the environmental review process, that this plot of land, the 61,000 acres, has existed since 1906, and before that it was in the hands of lessees, which put up a fence, and the fence was approximately 52 miles long. If you were to consider the 12,000 or so acres that are considered as alternative B in this environmental assessment and management plan, if you were to consider that to be a square shape of acreage, the approximate calculation of the perimeter of that fence would be about 17 miles. So you're talking about 17 miles as opposed to 52 or so miles of fencing that was in place back in 1896. And that was when it was under the lease with the Hawaiian Agricultural Company and Hutchinson Sugar Plantation Company.
Mr. Lau, is this in the record in terms of declarations or affidavits that were submitted in the SJ?
It's actually in the management plan itself. I can refer you to Jeff's 12 at 276.
Thank you.
Yeah. So, with regard to what this management plan is about, the no action alternative is basically that you have 61,000 acres, which eventually will be let to slide, increase of endangered species, decrease of endangered and threatened species, and this is all in part because of these invasive species, both plants and animals, and in particular feral ungulates. In this particular case, pigs are the ones that the plaintiffs are the ones complaining about. The pigs themselves are known to, and this is in the record also, okay, Jeff's at 12 at 301 to 302. The clash between the management and the feral ungulates, basically the feral ungulates damage, trample, eat understory, including endangered species and native plants, cause erosion, soil runoff, cause water turbidity. Their activities cause muddy puddles which allow root rot and mosquito breeding, and the mosquitoes are vectors for avian diseases such as avian pox and avian malaria. They also spread diseases to humans and dogs. So you have on one hand activities of these feral ungulates if unchecked, and on the other hand the alternative, in this case alternative B, which was selected by the state. And may I posit that alternative B is one that has is considered perhaps the least amount of impact on hunters, because it's in a remote area, it's rugged terrain, It's an upper elevation, the middle part of the 61,641 acres that make up the reserve. It's a 12,000 acre plot. Let me contradict what Mr. Dombrowski posited about whether hunting will be allowed after this 15-acre plan has been put into play. 15-year plan has been put into action. Basically, there's only 80% of the reserve that hunting is allowed. And in terms of the 12,000 acres out of the 61,000 acres, that's roughly 20%, right? So that leaves 80% that's still going to be allowed for hunting. And in fact, as part of the management plan, there's supposed to be increased access to the lower part of the reserve in order to facilitate recreational use such as hunting.
Mr. Lau, Mr. Dombrowski argues that the management plan just completely, to paraphrase, didn't address the traditional hunting issue. What is your comment to that?
I believe it did, and let me refer you to.
Does it explicitly contemplate allowing hunters to continue hunting pigs in the other areas?
Absolutely. If you look at the management plan, the state set aside 950,000 acres for hunting alone. Of that, 600,000 acres are on the Big Island. So if you look at the calculation in those terms, 12,000 acres out of 600,000 acres, then I think what you're looking at is more along the lines of 2%.
But yet, we are focusing on the Ka'u Reserve. So in this area and in this management plan, how about that? Does the plan explicitly address the continued allowance of the hunting of the pigs on
Yes,
the reserve?
I believe that it does. I want to refer you to particular sections where this is done, and let me refer you to Jeff's at 240, Jeff's 12 at 243, 244, and 320. So it is recognized as a valid interest of the use of the reserve. It's one of 7 action items that make up the management plan, and basically it has been addressed. Plaintiffs certainly can avail themselves of other hunting areas in the reserve if the practice is considered to be a traditional customary one, and we're not even, I don't think we're even there yet, frankly. And I understand Mr. Dombrowski to say that he believes that Mr. Dedman's declaration and the Wa'okeliopuna order as his proof that they've met all the standards that are required under Pratt, Kalihi, Pash, and Hanapi. I don't believe that to be the case. In fact, we've already said in our answering brief, this is Jeff's 12 at 211 and 224, that this pig is not the same pig that the Polynesians brought over, but it is believed to be a hybrid. So being a hybrid, how can it be a native and Hawaiian traditional customary practice if it's not one that was actually at the cutoff date of basically in the 1700s?
Let me ask you this, and I asked Mr. Dombrowski this. You and the state argues that the standard that applies here is, I guess I would summarize it as like the rule of reason standard that you have asserted, at least in your briefs. Would you agree that now that the Kila Kila o Haleakala case has been issued by the Supreme Court, that the standard that we should be applying here is whether there is a likely significant impact to the environment? Or do you have some other argument in light of Haleakala?
my understanding really that the Kilo Haleakala case did not specifically turn on the standard of was the EA sufficient. I believe that was an issue in that case, but it was not specifically the reason why that case.
Isn't the question there similar to this case, which is having done an EA, whether a FONSI was appropriate such that they didn't need to do an EIS? I mean, isn't that this case?
It is to extent, but what I believe is that the standards are themselves not mutually exclusive. The rule of reason is there because you're applying a reasonable standard to whether significance occurs, and this thing about may and likely that's talked about in Kepo versus Kane, it's circular in logic. They said it's may, and then if you look at the dictionary, then it's a certain degree of likelihood, and the likelihood that it may be significant. So you're back to may then, aren't you? And the facts of Kepo versus Kane, I mean, it's much different to the extent that they're looking at a 58 megawatt cogeneration plant, and what we're 11 million gallons a day of wastewater effluent,
Groundwater being
yeah,
utilized.
and a large amount of fuel being burned per day. So that being the case, it's almost like a sniff test that hey, it's significant.
Very different cases, I would agree. The question really is, though, I guess I would distill it down to this. You're still asserting the rule of reason standard. Where does the likely significance of environmental impact come in terms of your analysis then?
The likelihood of
A significant impact on the environment.
Okay. Basically, I think the rule of reason is saying it's up to the agency to decide whether they've reached that point where it is significant. And this is through the environmental process where they allow public comment and review so that the public commenting that, hey, these are significant factors that you should consider. If the agency takes it to heart, they can decide whether there would be significant impacts. So let me just say that there's a case that the plaintiffs cite, Unite Here, Local 5 versus City and County of Honolulu. They basically are pointing it to for the fact that they think that the Kepo'o versus Kane factor may have a significant effect. They believe the standard is where it raises substantial questions whether a project may have a significant effect. But if you look at that case is actually applying the rule of reason. And yes, it's to an EIS, or whether a supplemental EIS needs to be done, and that's because the court decided 20 plus years ago they didn't consider all the factors. So in that case, once again, it's fairly clear that some factor was left out, and it is a substantial question, a significant factor. So why? And if you look at the concurrence to that particular case, that concurrence is by the same author of the Kepo'o versus Kane opinion, and what he's saying is you apply the rule of reason. He agrees. So how does the rule of reason standard work? The court doesn't substitute its judgment for that of the agency as to environmental consequences. It just ensures that the agency did a hard look, and that the agency followed proper procedures unless it was, and the action is not going to be set aside unless it's arbitrary and capricious. The plaintiffs don't really understand what Price versus Obayashi is. They cite to Price. They say, they quote from Price, there are no factual determinations to be made regarding EIS sufficient adequacy. And then in their next sentence they say, unlike the comment in Price, questions presented in HRS section 343.5C4 plainly involve factual determinations. So they cite chapter and verse from Price, but then they say, but we're going to apply factual determinations anyway. And this is their misunderstanding that the circuit court applied procedural compliance rather than substantive effects.
So are you asserting there are factual issues here or not?
I'm saying that the court has to ensure that, I guess, looking over the shoulder of the agency still has to decide that all the bells and whistles required in the preparation of the EA were followed. Every one of those were followed, and it's just not where you give lip service to it. That
The
they actually,
procedural aspects.
Yes, the procedural aspects. So are there factual inadequacies, I guess is what you're asking me? I don't think there were, frankly. I can refer you to specific.
It's not a question of inadequacy. It's in terms of what standard, what rule do you apply in terms of determining an appeal like this, right? This is a declaratory relief action, right? This is initiated as a declaratory relief action, ruled upon summary judgment below at the Third Circuit, and but we're ultimately reviewing whether an EIS was required
Right.
in that context, right? So again, it just because the parties have disputed both below and here, what is the particular judicial standard of review? That's what I'm trying to have you articulate clearly, especially in light of the Kilikila Ohaliaka law case. Of what I'm hearing you say, and tell me if I'm wrong, is you still fully advocate for the rule of reason, but I also hear you at the end saying that in conjunction with whether there's going to be a likely significant impact on the environment.
I believe that you can harmonize the two standards, basically. Because where does the rule of reason come from? Rule of reason is basically applying, has the agency act reasonably in its compliance with Chapter 343 and 11200? And let me just, I have to quote this to you really quickly. Life of the land, it basically says, it's important to note that neither HRS 343 nor the administrative chapters administrative rules of Chapter 200 indicate the level of detail or specificity that should be included on any given subject. The statute and rules were designed to give latitude to the accepting agency as to the content of each EIS.
Doesn't it matter whether your question is, should an EIS be done,
Right.
versus an EIS having been done, is that EIS sufficient? Aren't those two different questions?
I don't believe so. I believe what you're looking at is a spectrum of environmental compliance. At the start, maybe there's no trigger, so nothing needs to be done. A little further down, maybe if it's a planning document, although there may be triggers, you don't have to do any further compliance. But then you get into these exemptions in EA, and then the EIS, and then possible significance. So where are you in the continuum, and how much compliance do you need to do? The agency has to decide that for themselves as part of the process. And my understanding is that they apply this rule of reason. So did they reasonably comply with each of these elements, at least if they start off with an EA? Or if they think that this might be of significance, there's a very good chance, then they jump directly to an EIS. And what you're applying is basically 343.5C4 and 11200-12 of HAR. So where does the standard come from? They are the same standards that are applied in both the EA and the EIS. And it's just you're at different parts of the spectrum, but you're applying basically the same standard. Sorry.
Well, let me ask them, bottom line, we're looking at whether the EA was, not whether it was adequate, but whether it showed that there should have been an EIS. So what, as a reviewing court of the circuit court's decision that sustain the agency's call, what is our standard of review? I hear you saying that we have to give the agency's decision deference, that so long as the agency has complied with the procedural requirements, then can we never overturn the agency's decision? And under what circumstances would we do so?
It's a very hard question to answer, obviously. If you, right. I think when you're in the Kipo'o situation and the Unite Here Local 5 situation, it's a lot clearer because there's obviously something like the 500-pound gorilla in the house in the Kipo'o case, and then the Unite Here, you basically, time has passed, a lot of time has passed, and they didn't consider all the considerations that we would normally do if we were to do in EIS now. So in this case, you look at what the compliance document says, and if it seems reasonable in the way that they've approached compliance, then I think you just leave it be whether you agree with the result or not, because you don't substitute your judgment. These are supposed to be professionals that are preparing this document. You can't, just because you got a retired biologist and some structural engineer, come in and say, oh yeah, that's rubbish. I think we want what we want. You can't do that.
So are you saying that the circuit court and the appellate court is only looking for procedural compliance?
I think that primarily you're looking at procedural compliance.
But under what circumstances, given procedural compliance, say, assume that was followed?
I frankly think it's the plaintiff's burden to come up with the circumstances, those substantial questions that they claim are out there, to say that's why it's wrong. But, to some extent, and your job is look at those questions and decide, all right, they seem to be compliant, or they're just false. It's wrong. But I think you do have to give deference, frankly, because I'm not the wildlife biologist. I didn't prepare this plan in conjunction with Fish and Wildlife, but my agency did. And they incorporated 11 different recovery plans into this management plan. So I'm thinking that they really did consider all the contingencies that are out there, or the majority of them. Sure, hawks eat crows, but that's a fact of nature. They're out there. Let's try to avoid hawks eating crows if possible. But hey, sharks eat monk seals. What can you do? It's a fact of nature.
I was going to ask you, because we talk a lot about the pigs and we haven't talked at all about the hawks and the crows. So what is in terms of the management plan, and particularly the hawks, the concern, of course, is that you were saying they're going to be introduced into this area, the crows are going to be introduced into this area where the hawks are there already, are existing already. So what is the plan in terms of trying to protect both species?
Okay. The hawks, there is a recovery plan that Fish and Wildlife has that is referenced within our management plan. The hawks apparently are doing pretty well because they're eating a lot of the introduced birds. And with regard to the crow, the alternative that was chosen was an area where there's the most amount of native forest and understory, the complexity of habitat that will allow the crows to avoid the hawks. That's one part of it. Number two, when you look at the plan, they're also monitoring where the hawks are distributed and when they're there in relation to where they're planning to release crows. That's in the management plan also. I can give you the reference if you need that.
I wasn't clear on this. Is there a plan to enclose the area where the a'ala would be introduced? In other words, completely enclose it, or is it just to be fenced and to be fully open?
I don't think it's specifically in the record, But my understanding is, yes, there's going to be enclosures.
I thought I saw a reference to that, but I wasn't quite understanding what that entailed.
An aviary?
Enclosures were going to be pre-release.
Say that again?
The enclosures were going to be pre-released to allow them to acclimate to the area
I see.
Yeah.
In the area,
where they're going to be released.
right, okay.
So like an aviary within that 12,000 acre parcel?
A cage, yes, a big cage. And they're all in captivity already, 100 or so individuals, 2 different breeding facilities. They need to be released.
And one other thing I want to be clear about, from reading the management plan, I mean, I saw pictures of like these steps that go over the fences. I mean, the plan is to allow people to access the areas even though it will be fenced. Is that correct? Okay, so the public will have access to these areas, and it's not going to be a fence that's going to be just 12,000 acres. It's going to be parcels within the 12,000 acres.
Absolutely.
All right.
Those things you're talking about called walkovers.
Walkovers.
And they're going to be 2,000 to 4,000 units that they're going to fence at a time and these are management units. The idea being you go in there, you remove all invasive species, you remove any kind of disease vectors and whatnot, particularly invasive ungulates, but not limited to them. And then you may supplement with other native plants. And so it's going to be portions of the 12,000, not the entire 12,000 all at once. And this is a 15-year plan, and I think we're subject to budget constraints as well.
15 years to complete the fencing as funding arises.
Yes.
And what does the plan speak to in terms of how long the fencing exists? Because there was some concerns about other areas where fencing is leaching or what, I don't know what the specific wording is, but basically old fencing is in place and it affects the environment. So what's the long-term plan once the fences are in place?
Okay. To be candid, I don't really know whether it's going to be there in perpetuity. But my understanding, just logically, would be that it's there as long as protection is needed. And with regard to whether it needs to be replaced or not, my understanding is it would be repaired if there is damage to it.
And that's in the plan.
Right. But, fencing, this is no new high technology kind of structure. It's been around forever. As I said, back in 1896, they put in how many miles? 52 miles of fencing.
Yeah, your reference to the record on that, as you indicated, is in the plan. How long did that fencing exist until when it was leased property?
I can't answer that
All
one.
right. Just thought I'd try.
Yeah. Haven't been around that long. So with regard to the traditional customary rights, Article 12, Section 7 says that it's subject to the state regulation. So if they claim a traditional customary right, it is subject to regulation, and the state does go through a balancing of these Native Hawaiian interests and the state's interests. And the state's interests in this case you would think would prevail because you're protecting all these endangered, threatened species as opposed to pigs, which apparently are in plentiful supply by comparison. I think I've covered pretty much all I wanted to. Unless the court has further questions about specifics?
Fine, thank you.
Okay, thank you.
I'm glad that I learned something here today that I've been questioning ever since I got involved in this case is what's the backstory for this idea of introducing the crow into an environment where the hawk resides and fencing which didn't, have any ceiling on it so the birds could fly back and forth. And so I think, if I heard correctly, that Mr. Lau said that it was from a wild-eyed biologist in the DLNR. So that kind of gives me something to hang my hat on and try to figure out why they did this. We have the declaration of Ryan Kahatsu, who's provided his information about how fatal it is for the crows to be put in that environment, which is a habitat for the hawks, why that location was chosen as opposed to other locations on the Big Island. That's what he's raising as a factual issue. And as a matter of fact, I think there's a lot of factual issues. I think that one of the questions that was asked when I was, and I think Mr. Lau addressed it too, was this idea that they could continue to hunt and so forth, and that's addressed in Mr. Dedman's declaration. And if I could just briefly read it, this is his declaration, R805 to 814, and I'm directing it to 813. And he states, under the heading Cultural Resources, there has been no input obtained from Native Hawaiian practitioners, which include members of PDF and myself. There's been no work to work with traditional practitioners. In fact, the suggestion that it will be done after implementation of the plan is absurd because it will be after the effect of the fencing and destruction of the ungulates. The lofty goals delineated are clearly short-sighted regarding the section entitled Secondary and Cumulative. The failure to conduct past monitoring of human hunter reports means that their goal is short-sighted. And then he goes on, and the declaration covers some other points. But our brief, too, our reply brief addresses this issue, and I think in terms of the same question in the reply brief at pages 8 through 10. And the issue that we point out here is that question of the impact on the cultural practice is a relevant factor in the significance analysis that's required in HAR 11200-12B with regard to the destruction of a natural or cultural resource, curtailment of the range of beneficial uses of the forest, and the effects on economic or social welfare and cultural practices of the community. And one thing that we point out is that we're talking also about a food supply here. And that's one of the admissions we highlight in our briefs that cites to the EA page. This is page 61, but in the record is 218. And it says, one of the most prevalent and popular cultural practices is hunting, which has occurred for generations in Kau. And I'm skipping a few sentences. People in Kau depend on hunting for food to save money, and it is part of their lifestyle. According to Uncle Kalani, Auntie Susan Pua, Uncle Larry Galban, and Uncle Pee Wee Brightheart, among others, hunting is not a sport, but a means of subsistence, and they only take what they need. And so that is one of the impacts that is significant, and that has to be computed into this wild-eyed biologist here of coming up with this plan that's going to completely deprive the Native Hawaiians of their constitutional rights under Article 12, Section 7. I asked Mr. Lau before the proceeding if he would oppose my request for judicial notice of an article that was published on the website for the DLNR that talked about it was entitled Experts Work to Improve Alala's Chances, and it substantiates, this is posted on March 21st, 2017, and it documents the fact that the first 5 Alala all-juvenile males were released in December into Pu'u'ama, I'm killing the pronunciations, and I apologize for that, the natural area reserve, but within a week, 3 were found dead. I'm sorry. What's equivalent to an autopsy was performed, found that the 2 birds were killed by its natural predator, the Hawaiian hawk, and 1 died of starvation. So, I mean, this documents the concerns that were raised in the Declaration of Ryan and the predictions that he made in his declaration, Ryan Kahatsu. And so, again, I just ask that this subject and this whole question be sent back for an EIS. I think all the questions that were raised are really significant and may be significant. And we've itemized them in our briefs, and I've just covered a few. And I would, again, want to thank you for this opportunity.